Very briefly tell us the facts, very briefly.
Yes, Your Honor. Your Honor, on 24th of February 2015 at 9 in the morning, some secret information was received by the Special Cell of Delhi Police that two suspect persons will be carrying FICNs on 25th of February 2015
Hmm.
by the train going from Malda town to Delhi. Then on the very next day, as per the information received, the train was raided. That is the general coach number 2 of Faraka Express train, train number 13413. So,
Hmm.
on its arrival at platform number 5 of Old Delhi railway station on 25th of February at 10:55 hours, during the raid, sir, the high quality fake Indian currency notes of total face value rupees 10 lakh was recovered from the accused person, sir, namely Samir and Monu. After the recovery of the all of the things that they were carrying in their possession, the accused persons were arrested, sir. Your Lordship, the further discussion is constructed on these provided facts. So, if the facts are clear, the Council seeks permission to proceed with the arguments at once, sir.
Proceed, please.
Thank you, Your Lordship. Your Lordship, the latent maxim, the actus non facet triumnisi mensit rea, tells us that for any act to be illegal in nature, it must be done with a guilty mind. This maxim can find its importance under Section 14 of the Indian Evidence Act 1872, which states that facts which indicate the state of mind or intention are relevant in nature, sir. Your Honor, the criminal intention of the accused is very much clear from the aggression which they have shown while delivering their speeches to instigate the people to wage war against the government, especially the remarks which the accused persons have made, that is, दुल्हन को सजाना पड़ेगा और दुल्हन को सजाने का वक्त आ गया है. These cannot be ignored at all, sir. So, in the case of Captain Abdul Sattar versus R.H. Mendelssohn, it was stated that the intention behind the act is to be understood, sir.
Hmm.
So, one cannot take the shadow of benefit of doubt in such type of serious offences. Your Lordship, I'll kindly request you to refer to page number 24 of the Defence Counsel's written submission, where they have submitted that prosecution has to produce evidence not only to show that each of the accused has knowledge of object of the conspiracy, but also of the agreement. Your Honor, at this point, I'd like to state one case of CBI Hyderabad versus Narayan Rao, that in which it was held that the agreement to do an act is the essence of criminal conspiracy. Direct evidence of conspiracy is rarely available. It has to be proved on the basis of circumstances.
Hmm.
Your Honor, the Defense Counsel have also agreed to this point that direct evidences are rarely available of such conspiracies, whereas circumstances affirms the same in their written submission, sir. Therefore, Your Lordship, in the present case, we have enough circumstantial evidences which proves the guilt of the accused person, sir, which proves that there were malified intentions of the accused persons behind all the acts that they were doing, sir. First of all, sir, some people of the accused association were ignorantly talking about the transfer of FICNs at Guddu's pawn shop, who informed about that incidents to the police on 24th of February. So, when Guddu Singh received that information, he immediately went to the police station. Then, on the very next day, when the police actually raided the train, the accused persons were found with the FICNs. Secondly, sir, the remarks made by the accused to instigate the people are so horrendous that it will do nothing for the people's welfare. In fact, it will exploit their lives, which they already living. Your Honor, here I'd like to mention Article 19 of our Indian Constitution, which the defense might would be taking the shadow of, which talks about the fundamental right of speech and expression. Your Honor, Article under Article 19, subclause 2 itself, there are many restrictions given over there, in which one of the restriction is that you cannot undertake this provision, this much provision for to instigate the people. But in the present case, sir, the organization that we are talking about is exercising its fundamental right without any limitation and leading to the incitement of an offense. Thirdly, the fact that they all agreed to be a part of an association even after it was declared to be unlawful, as it went against the sanctions imposed by the government of India. which is the lawmaker gives us reason to believe, as per Section 26 of the Indian Penal Code, that all had prior meeting of minds were aiming towards a common objective of going against the law, sir. Fourthly, Your Lordship, the technical evidences found in the form of call detail analysis, the entire location of their mobile phones, the transcript on important dates, along with the confessions made by the accused persons, which also discloses about the same dates, is a matter of fact which is of utmost importance, sir. Your Honor, I'll also request you to kindly refer to page number 18 of Defense Counsel's written submission,
Hmm.
point number 10, where they have been trying to mislead the court by stating that there was absence of location tracks, whereas location of mobile phone of accused persons is clearly given in 17.16 of the Moot proposition, where the last location of Peter to whom the money was to be delivered was found to be of Pulwama, sir.
Hmm.
Your Honor, though Section 26 of the Indian Evidence Act and Article 20 of our Indian Constitution protects one's right against the self-incrimination, but Your Lordship, it is held in many cases by the Supreme Court and many other high courts that the confessional statements can be admissible if they are corroborated with the circumstantial evidences, sir. Therefore, it is humbly stated in the court that mens rea, that is the criminal intention, was always there in the accused person throughout they started their activities. That is while delivering their speeches, carrying bags of FICN, also depicted through their call records, sir.
Hmm.
Henceforth, the alleged sections against the accused persons are completely appropriate as the most important element of every crime, that is, the criminal intention of the accused persons is always there, and therefore they must be convicted accordingly. So, moving forward, Your Lordship, I would like to state the maxim of ignorantia facti excusat, ignorantia juris non excusat. It is a Latin maxim which means that ignorance of fact is an excuse, but ignorance of law is no excuse, sir. Your Lordship, Samir and Monu were found with two bags that were filled with FICN, which they haven't disclosed as if why they were carrying it. Also, it was held by the Kerala High Court that the proof need not be necessarily by direct evidence. The various circumstances leading to the seizure of forged notes and the manner in which the accused came into those possession of those notes, these all must be taken into account. And this leads us to think in this case that they had the knowledge of such notes, that is Samir and Mono, that they were carrying FICNs with them. Also, Your Honor, just mere denial of the reason of or refusing to state a valid reason for carrying or possessing the FICN does not save the accused at all from the charge against 489B and 489C, because mistake of law is no excuse and mere denial is no defense, sir. Since the accused persons were running an organization, so an excuse on their part that they were completely ignorant of the fact that they were carrying FICNs with them should not be admissible, sir. Therefore, the security of the nation, these facts must be considered with great caution and awareness. Your Honor, I'd request you to refer to page number 25, para 27 of the Council's written submission, which states that there was delay on the part of NIA and the CFSL agency, which is not true, sir, as they have submitted their reports on time. So, for CFSL to submit its report, there's a time period of 6 months, sir. And I would say that there is no time for the special cell Delhi police to transfer the case to NIA also, sir, because it is nowhere written to submit the report, sir. Therefore, um, with this, they're not only questioning the competency of the Delhi police, but in the hustle of defending the accused person also, sir, they are putting the national security at stake, sir. Therefore, it is humbly stated that the accused person should be held liable for the commission of offences under Section 120B, which talks about the punishment for criminal conspiracy, Section 489 and 489B and 489C, which talks about the use and possession of forged or counterfeit currency notes or banknotes. Section 121 for waging war or attempting to wage war against the government of India. Section 123 for concealing with intent to facilitate design to wage war. and Section 201 for causing disappearance of evidence of IPC, that is of 1860, and Sections 16, 17, 18, and 20 of the Unlawful Activities Prevention Act 1997, sir. Thank you, Lordship. Your Honor, now I'd like my co-counsel to take the proceedings forward. But before that, I would like to ask you that if there are any questions from your side.
What is the stage of the case right now before us? You
My
are saying that
apologies,
hold
sir.
them liable. You are saying hold them liable. Has the trial happened?
So the trial is going on.
Correct. So it is at the stage of taking cognizance. Charge sheet has been filed, right?
Yes, sir.
So we need to see the prima facie fact or allegations that are there. What is the call record details that you have? What are the call record details?
Wait a minute, sir. So specifically, we're not having any call detailed recording that they were talking with each other. But sir, the track, the location that they were found of, for example, Peter, to whom the money was to be delivered to Pulwama, according to the even according to the confessional statements that Monu and Sameer were carrying the money from Malda town to Delhi, and then it is to be delivered to Peter in Pulwama, where also as a technical evidence, sir, the location of Peter is found to be of Pulwama. That is his last location, and then onwards when
How are you showing that Sameer and Monu had knowledge of the notes being counterfeit?
Yes, sir. So, Sir Sameer and Monu were the part of an organization, and they were one of the leading personalities of that very particular organization, sir.
What are the activities of the organization?
So, they all acted against the government to appraise, as they are taking the defense that they were acting against the government to stand by the oppressed classes, sir. So, sir, we can expect from a liberal, from a prudent man, that if he's running an organization and if he's carrying some bags on the name of that organization, he's well known with the fact that what he's carrying with him in those bags, sir. So it is prima facie very much clear.
Was the activity of the organization an illegal activity?
So the activity, the thing that they were doing was not specifically, we can say that they were delivering the speeches against the government. And also, sir, I would like to mention that they were declared to be as an unlawful assembly by the government of India, sir.
I see. Okay.
Yes, sir.
No, but for what reason was they declared to be unlawful?
So because the speeches that they were delivering to incite the people against the government of India.
How are you connecting that with counterfeit notes? That's what I'm asking you. So the activity, they may have been declared unlawful,
yes,
but how are you connecting the counterfeit knowledge being with them of the counterfeit notes?
So, yes, I get your question, sir. So what I'm trying to state here is that they were enough responsible citizens, as I'm saying that they were running an organization.
All right.
They were one of the leading personalities of that very organization. So if they are, for the purpose of the organization, if they're carrying something from one place to another, they must be aware of the fact that what they are carrying with them.
See, it was very high quality counterfeit, right?
Yes, sir.
Anybody could carry and believe that they are actually genuine. How are you linking that they had knowledge of that being counterfeit? Because the analysis result shows that they were very high quality.
Yes, sir. So, sir, we have also we are also aware of the fact that they were getting the donations from the foreign countries, that is Bangladesh, and the other enemy countries that we are at war with. So that's why, sir, I would again say that
there is an assumption.
No, sir, they are getting It has also been stated in the confessional statement that they were taking the donations from the enemy countries, that is Bangladesh and West Bengal.
Okay, carry on, please.
Thank you, Lordship. Over to you, Ms. Counsel.
My sincere greetings to the bench. Without any further ado, I'd like to move forward with my arguments. Your Honor, before I move forward in my arguments, I'd like to state a case mentioned by the prosecution in our submission of memorial on the page 27, if you'd like to refer. In Anikul SK versus National Investigation Agency, it was stated that even when direct evidence is not found, circumstances are are enough to well versed with the state of working of a situation under
Mm,
which accused is held liable. On the basis of the judgment, Your Honor, I'd like to establish the chain of evidences found all along by police and NIA. So, Your Honor, number one, there was a raid by special cell of police on the basis of information received by them from Guddu Singh, the farm owner, at platform number 5 of Old Railway Station. On search, Monu and Sameer, accused 1 and 2, were detained. Their bags had 250 notes of fake Indian currency notes each, of worth rupees 10 lakh of value. FIR was lodged. All formalities were done. Guddu Singh's statements were recorded as per the procedure of Section 161 of CRPC. On further inquiry of accused Monu and Sameer, they revealed procuring FICN from Kallu Mama, another suspect of their plan. CFSL report submitted the notes recovered to be of high quality fake Indian currency notes. Later, as per the confession, Peter was to collect the FICN notes who would have delivered it to Pulwama and JNK. Your Honor, if you'd like special attention on the first point I made, they, that is accused 1 and accused 2, Monu and Sameer, used to receive consignments of FICN from Kalichak Malda and travel in general coach as per the information received. Your Honor, which corroborated with the circumstances they were arrested on. They were arrested from the Paraka Express general coach with the possession of FICN, Your Honors, thus corroborating under Section 27 of Indian Evidence Act. General coach of Paraka Express with rupees 10 lakh worth FICN, which proves the offence charged under 489B and C of Indian Penal Code, Your Honors.
mm,
Although Section 25 of Indian Evidence Act bans the admission of confession made in police custody, however, principles stated under under Section 27 of Indian Evidence Act says that if confession of accused is supported by discovery of facts, then it may be presumed to be true, and because information distinctly relates to the fact discovered, it can be found admissible thereof.
yes.
Now that Kallu Mama has been found in the context on the basis of further admissions made by the accused persons. Kallu Mama used to take instructions from Suhail, that is accused 5, who was
Mm,
planning to carry out bomb blast in Pulwama on Indian Army convoy, and that he was in touch with Lashkar-e-Taiba. I know that's a huge allegation, Your Honors, but
mm,
we're very well known with the organization Lashkar-e-Taiba to be banned under the UAPA Act. Even
mhm,
though the conviction couldn't be proved as for the lack of physical evidence and Sameer absconding, Kallu Mama, in his witness statement, mentioned on receiving funds from across the country of Pakistan and Bangladesh, countries which our country was with war at and still is with war at, and has showed in past the incidents of putting our country's sovereignty and integrity at stake by putting up such terrorist acts, Your Honor. Why would the countries who are at war with our nation be so supportive and worrisome about an anonymous association of West Bengal, especially when it come out from a village which is not even recognized by the people of India fondly?
mhm.
Not for this secretive agenda, Your Honors. Your Honors, hence establishing some sort of criminal link between the two and putting some sort of sense into the statement of confession of Sameer and Monu. And Your Honor, if you see the paradigm set by them, as soon as the inquiry began and names started to came off, police went on search for Peter, accused number 3. And he was found absconding from his residence. He was a resident of Malda town itself. Later, it was found that he committed suicide in Rajasthan, whereas his mobile location earlier was found of Pulwama, from where he was supposed to carry out FICN to further their common intention of the criminal intention of putting the sovereignty and integrity of India at stake and conducting the bomb blast on army convoy. Technical evidence shows that whereas Sameer and Monu's mobile location was of West Bengal, Madhya Pradesh, and Delhi, Peter was found to be of Pulwama, and it was Peter, as per the confessional statements of Sameer and Monu, who was to take money to Pulwama for the attack they were planning on army convoy. So, all this while they were in constant touch with each other, not to forget the technical evidences, although because of protection under the fundamental right to privacy, corresponding conversations could not be received, hence not authenticated under Section 65 of the IT Act, and the prosecution accepts the fact. But circumstantial evidence found in the light of confession, corroborating with the situations arise thereof, clearly shows them liable and presents a prima facie case thereof. As for the defense's submission on page 20, there was a delay. There was a delay by the CFSL in reacting the submission of the report, whereas the total time period is 6 months. And as for the moot court propositions facts, they gave back the report on April, whereas at Feb the report was submitted to them. The inquiry was submitted to them. Thus, the 6 month time period has not expired, and taking a defense thereof and clearing the what the defense statement has thus stated. Your Honor, now coming to the fact that as influential as their organization can be seen, as Your Honor also questioned on the activities of the organization, as influential as the organization can be seen, that Sameer and Monu at once was so influenced that they called government policies double standard, and also were keen on participating in all the activities, and that after attending their organization at first they were so influenced that they were ready to take the bag from one place to another without knowing what they had inside it, which is, I think, the clear denial of possession of the counterfeit notes, which cannot be justified thereof. Even though possession does not amount to offense, mere denial cannot be justified. Your Honor, Section 16 states punishment for terrorist act. UAPA includes an act that is likely to threaten or likely to strike terror in people. Although it gives unbridled power to the government to brand any ordinary citizen or activist a terrorist without these acts being actually committed, but understanding the nation's security at threat and understanding the facts that they were called unlawful assembly, yet they continued to work as one. And they continued to oppose the sanctions which were implied by the government on them, proves the criminal intent, Your Honor. Your Honor, UAP is imposed when there is threat to the security of nation. The allegations made of accused persons were planning a bomb blast against their own country, whereas the problem stated by them was with the government policies, which clearly shows how they violated their sacramental fundamental rights, because every fundamental right come with the provisions of restrictions, reasonable restrictions, and in question of reasonable restrictions, we have sovereignty and integrity of nation and morality, and immoral and unlawful assembly by the government way prior to their arrest, Your Honor. Your Honor, we've all heard of Naxalites. They're common people who want equal social status and financial status for all. It all began with one when one was not denied some sort of support by the government, and he started an organization against the government policies. And we all know what Naxals are now, and they're also banned under UAPA as they're termed as Maoist community. Their ideology was clear that they're fighting oppression and exploitation to create a classless society according to them, for which they target government, their controls, and uses unlawful means to show their so-called affection for their upliftment. In the present case, we can completely argue and we can completely understand by the state of facts as appeared, by the speeches they used to deliver, and the sensitization programs started by them to aware the villagers as per them, but I'd say to mislead the villagers as per them. And they used to receive funds from Pakistan and Bangladesh, which again the countries are we are war at, and defense has shown no justification thereof. Your Honor, not to forget the statements used by them. India not being a country worth living and country of intolerant, and that dulhan ko sajana padega, making defamatory and obscene remarks on a country where the country and our map is called Dharti Ma. So such obscene words are defaming the word Ma as a country is very affectionate upon. And further statement says Dulhan ki vidai ka waqt badalna padega, when government imposed sanctions on them so that they should not receive funds from a country we are war at. And thus was the statement as the witness has himself accepted in his witness statement. And that Dulhan ko sajane ka waqt aa gaya hai are full of innuendo and some left-wing extremist remarks given by them, questioning the sovereignty and integrity of a country, Your Honor. UAP allows searches, seizures, and arrest based on personal knowledge. That statement providing credibility of Guddu Singh's statement because it was in the best interest of public when the information was received, Your Honor. Section 17 states punishment for raising funds for terrorist acts. proven by the admissibility of facts from the statement of Kallu Mama that they used to receive funds, which have clearly been corroborated with the statements thereof before. Benefit of doubt should be given to the prosecutor here, as there is lack of physical evidence of any activity prior to arrest. But defendants cannot form their argument on basis of a weakness, because in the case UAPA, Your Honor, I'd like your special attention on the next line, that the onus to prove the argument is on the one who is charged guilty under UAPA, that is Samir and others in this case, and not on the one who affirms. Your Honor, further Section 18 states punishment for conspiracy, and confession and evidence brought up from them stands admissible under the principle of Section 27 of Indian Evidence Act, considering all the evidences found all along and all the confessions made by them corroborated with the facts thereof. It was mentioned in Swami versus State 1952, if you would refer to page number 29. There is no rule of law which says that conviction can't be based upon uncorroborated confession. However, as a matter of prudence, it is usually considered safe to look at confession in the light of all evidence on record, and all the evidence on the record in the present case shows the accused liable. And in the case of Hemraj versus State of Ajmer, it was held that the confession recorded after the commencement of inquiry or trial can still be used in evidence as per the Section 27's principle of Indian Evidence Act, Your Honor. Your Honor, concluding my last Section 20, punishment for being member of terrorist gang or organization. On the basis of FICN found, and being the active members of the group, they were sent by Kallu Mama for the delivery of FICN. Active participation of these two and delegated orders by Kallu Mama and links with Suhail takes us to believing that the chain of evidences found all along are thus admissible. And under Section 34 of IPC, when a criminal act is done by several persons in furtherance of common intention of all, each of such person is liable for the act in the same manner as it were done by him. Your Honor, if you would please allow me to say the prayer as I'm done with my fact of statement.
Yes, yes.
Much obliged, Your Honor. Therefore, in the light of issues raised, arguments advanced, and authorities cited, may this honorable court be pleased to convict the offenders for their misdemeanor under the charges as mentioned above, and/or pass any other order it may deem fit in the interest of justice, equity, and good conscience. Thank you, Your Honors. If any question.
Conviction before trial.
Sorry.
The prayer is, you're saying convict.
Convict the offenders for the misdemeanor under the charges as mentioned.
Because you file the charge sheet, frame charges, and not
Right.
Convict, because unless the trial goes, how can you convict anybody? All right.
So I understand your question, but as per the facts of Moot proposition, this is the final stage of trial. Hence, I think after that, it's the decision of conviction which is to be.
I see. All right. All right.
Thank you, Your Honor. So,
Let the other team start.
Now, sir, it's team
Defense.
530.
Yes.
They have to respond.
Oh, 561.
561, yes.
561, yeah,
five.
sorry. This was 530, yeah.
Right.
My mistake. Yes.
Much obliged, Honorable Court. Your Honor, we seek pardon for the network connectivity issue for
No
respect
problem.
to.
No problem.
Should I start, Honorable Court?
Yes, please.
Much obliged. May it please the Honorable Court, the counsel is appearing on the behalf of the defendant in the case of State versus Samir and others. The counsel seeks permission of your lordship to state the statement of jurisdiction. Much obliged. The accused humbly submits to the jurisdiction of the Honorable Learned Special Judges NIA under Section 22 of the NIA Act 2008. The counsel seeks permission of your lordship to present the statement of facts.
Yes.
Much obliged. The facts present in the instant case are as follows. The accused were engaged in a social initiative group as a means to bring about positive societal change in the small town called Malda in West Bengal. Pursuant to the same, they were innocently traveling to complete their first assignment to transport bags from Malda to New Delhi via Farakka Express. The accused 1 and 2, namely Samir and Monu, were apprehended on the account of transportation of fake currency via Farakka Express on 25th February 2015 at 10:55 hours. The apprehension, your lordships, was done in pursuance of an information which was given to the special police cell of the Lodhi Road by one Guddu Singh, a pawn shop owner, who apparently got this information via a secret source and thereby applied the information to the police. An investigation was carried out on accused 1, 2, and 3 with the police and the investigation agency traveling from Malda to Rajasthan to Madhya Pradesh to catch the relevant perpetrators, and the court may note without any success. Numerous penal and terrorism charges have been levied on the accused, thereby giving rise to the present case. The council now seeks permission to present the statement of issues.
Yes.
Much obliged, Honorable Court. The first issue up for perusal before your lordship is whether the actions and intentions of the accused in this matter successfully warrant the penal charges that have been framed against them.
Right.
And the second issue is whether the accused were engaged in a terrorist activity, thereby bringing them under the ambit of the Unlawful Activities Prevention Act 1967.
Correct.
It is submitted before your lordship that the council would be appearing, would be contending on issue 1, and my co-counsel would be taking up issue 2. Now the council would present the arguments advanced. Your lordship, the argument presented before your lordship is fourfold. Firstly, the accused are just patsies being framed in the instant case that has been brought against them. Secondly, there is a plethora of incongruity in the charge sheet that has been made by the Special Police Cell Lodhi Road, New Delhi, and the National Investigation Agency. Thirdly, Honorable Court, the human rights of the accused have been compromised due to the extended detention of 6 long years that they were subjected to. Fourthly, there is a superfluity of contradictions in the contentions which has been presented by the prosecution. And apprising the above, the accused are simply put harbingers of change in a society, asking for change from a threatened government that has cast off the vicious net to stop any political dissent against them. The council would elaborate on the same in her subsequent arguments. The accused, Honorable Court, as has can be made out from the prosecution witness 2 statements, in light of the defendant 1 and 2 statement, that on the day of apprehension, that is on 25th February 2015, they were innocently and unassumingly traveling to complete their first assignment for their social change group. And their conduct, wherein the accused has made no attempt to flee and were moreover mortified to find themselves arrested by the police, that accused 1 fainted due to sheer shock. The accused had merely initiated a protest, Honorable Court, a peaceful one at that, and had acted against the redundant policies of the party in place in their town Malda. They were rewarded handsomely by the party in power, who spun a net of charges so disquieting that it makes the accused seem like terrorists instead. Secondly, glaring incongruities can be noted throughout the charge sheet, and the council would like to bring them forth for the intention of your lordship. Firstly, the search memo of the accused, which was made, that has been presented for the perusal of your lordship in Annexure D. In Annexure D, the search memo has been made 2 days prior to the information of which was given to them by Guddu Singh, and the arrest which took place on 25th. The search memo's date is 22nd of February, and the arrest took place in 25th, which is in violation of the established norm. Secondly, the descriptions which have been mentioned in the FIR by the Special Police Cell are in contradiction of each other. Thirdly, there has been a mention of a prosecution witness, namely Shaurya Khan, who has been stated as prosecution witness 5, whose testimony has not been presented for the perusal of your lordships. Fourthly, the location sketches of the alleged mention of the houses which were used for making alleged fake money has also been left out and not been provided on record. Furthermore, no specifications of the incriminating evidence which has apparently been found in Peter's or Sohail's or Kalu Mama's residence has been provided. Again, Honorable Court, no conclusive proof of the true of the culpability of the accused also has been placed on record. The information men make the allegations which have been put by the prosecution to be a craftily knitted trap to frame the accused. Thirdly, Honorable Court, courts are expected to appreciate the legislative policy against the grant of bail, but the rigors of such provisions will melt down where there is no likelihood of trial being completed within a reasonable time, and the period of incarceration has already undergone a substantial part of the prescribed sentence. Such approach would safeguard against the possibility of provisions like Section 43D, subsection 5 of UAPA, being used as sole metric for denial of bail for the wholesale breach of the constitutional right of to speedy trial. It has been further laid. This was a recent case which was filed, and the court opined. This apex court has opined the above in the present case. In the case which has been mentioned by the council. It has further been laid out in the case of Babu Singh versus State of Uttar Pradesh that the issue is one of liberty, justice, public safety, and burden on the public treasury, all of which insist that a bail is an integral part to a socially sensitive judicial process, which keeping the accused in custody for 6 long years from 2015 to 2021 is a breach of their liberty and human rights, which have been enshrined under Article 21 of the Constitution of India. The Council is saddened to present that the powers of restriction have been flagrantly flouted and exceeded in the present case by the said law enforcement authorities, and they have been playing with the liberty of the accused in the present case. A criminal, as has been enumerated and has been mentioned by my learned friend as well, in VC Shukla, is conceived as having 3 particular elements: agreement between 2 or more persons, and they should the agreement affected should constitute a criminal object, which may either be the ultimate aim of the agreement or may constitute the means or one of the means by which the aim is to be accomplished. In the present case, Your Lordship, there is an absence of agreement or consensus ad idem and a criminal object for carrying out the transportation of fake currency, and the alleged bomb blast to take place in Pulwama, as can be noted from the utter lack of knowledge of the accused with regard to the existence of the fake currency in their particular bags. Knowledge, as has been laid out in the cases of Esha Singh versus State of Andhra Pradesh and Ajay Agarwal, is the most important ingredient of the offence, and that in a case where criminal conspiracy has been alleged, the court must inquire whether the 2 persons are independently pursuing the same end or have they come together to peruse this unlawful object, which in the current instance, the accused have not done either of the same. It is thus submitted that it would be a dark day in the history of the judicial system, Your Lordship, if these innocents are put behind bars for just raising their voice against the government. With this, the council would yield her time to her co-counsel, who will be dealing with issue 2.
Yes, please.
The council says permission of
I have
honorable
a
judges.
question. I have a question.
1 minute. Yes.
Yes, sir.
See, you were found to be carrying that kind of money, rupees 10 lakhs.
Yes.
Now you were carrying that kind of money. Now under section 106 of the Indian Evidence Act, now it is to your knowledge as to why you were carrying that money. Have you given any explanation whatsoever as to why you were carrying such kind of money in that bag? Isn't it unusual? Can an inference not be drawn that you were actually, there was complicity in the criminality?
Much obliged, Honorable Court. It has been presented that again we were not effectively carrying the money because we did not even have the knowledge of the existence of money in the bags in the first place. And that has been brought out by the fact that the search memo has been prepared beforehand. The search memo which talks about the apprehension of the money in the case has been made 2 days prior to the information which has been given by Kutu Singh in the first place. Also, the descriptions in the which have been provided in the FIR, there are 3 people who have been apprehended by the in the FIR. Your Lordship, there have been 3. The descriptions of 3 individuals have been given, but there are contradicting descriptions. Also, the special cell has alleged that they got only 2 accused, Sameer and Monu, whereas the 3rd person come up. And these go on to show that we've been framed in the incident case and we are the victims. We were not actively transported.
Have you taken the defense in your arguments? Have you taken this defense?
Yes,
that there
yes,
are
Honorable Court.
contradictions and that you have been framed or this
Yes,
consignment has been planted?
Yes,
Have you
yes.
taken this defense?
Yes,
I think I've seen somewhere you have admitted that you were found with the bag, but you had no knowledge as to the contents of the bag. That's the defense you have taken.
Which goes on to show that we've been framed, Honorable Court. That's a supplement to the same.
That's in the confessional statement.
Yes, Honorable Court, and which won't be admitted due to Section 25 of the.
Very good, very good.
Yes, please go ahead.
The council seeks permission of honorable judges to proceed with the second issue, which is whether the actions and intentions of the accused in this matter successfully warrant an ongoing trial for which they were charged under UAPA. Honorable judges, in the course of this contention, it shall be humbly submitted that this is a case of our citizen becomes victim of government's malfaction. The defense submits that the prosecution has been unable to prove beyond a reasonable doubt that the accused, namely Samir Monu and Kalumama, were acting in consonance to their alleged prearranged plan of terror conspiracy. It is contended that in its entirety, the accused were not involved or concerned with any terrorist act, and that in any case, none of the accused was even a part of any terrorist gang or organization at all. However, honorable judges, this charge of terrorist act is under section 15, subsection 1, clause A, subclause 3A is subject to rule 6, which lays down the procedure that has to be followed to apply a terror charge under section 15 of UAPA. This rule of the investigation of high quality counterfeit Indian currency offences rule. To this purpose, submissions shall be twofold in line with the requisites of section 6, namely procedural formalities, condition precedent endorsing that mere possession is not a terrorist act, furthering the corpus delicti rule. The council hereby professes that to attest indemnity under the first head, the law mandates an investigating officer to forthwith send the seized currency to the notified authority, but not later than 48 hours of the seizure, expecting in return from the said authority a preliminary report within 15 days of receipt of such samples. The heir of any element which stages discrepancies in this regard could oust the prosecution of the opportunity to sustain the continuing threat of UAPA on the heterodoxies. However, the facts of the instant case assent the discrepancies in this regard, as neither of the formalities were performed on time. In view thereof, the stringent conditionalities contained in Rule 6.2, which imposes the aforementioned time limit, stands unsatisfied. The second of the twofold edict the observance of any one or more conditions of Rule 6.4 while discharging duties under this Act. Your honorable judges, by this Act we mean UAPA. The pronouncements of Hitendra Vishnu Thakur and others versus State of Maharashtra, read conjointly with Uma Shankar versus State of Chhattisgarh, corroborate this conclusion that the investigating officers or any such officer's demeanor in failing to observe the stringent conditionalities does not only bring forth the high-handedness of the prosecution, but is conjointly capable to duly stop them from the opportunity to embroil the accused in the stockpile of charges framed. As a sequitur to the aforementioned unconfirmed conditions, the high-quality fake Indian currency notes were seized from their respective secret cavities of their bags, furthering the contention that currently there is an irrebuttable presumption of actus reus and mens rea. Irrebuttable presumption of mens rea, and that the accused did not have consciousness of any criminal connotations that the bag harbored. While we don't deny that the accused were participants in the annual All India Conference of Youth Union that was held on 25th September 2013 and its subsequent projects. However, honorable judges, they made convenient scapegoats. In its anxiety to suppress dissent and in the morbid fear that matters may get out of hand, the state has blurred the line between constitutionally guaranteed right to protest and terrorist activities, forgetting that if such blurring gains traction, democracy will be imperiled, as brought to life in the cases of Devangana Kalitha versus State of Delhi NCT and Sadab Ahmed versus State of NCT of Delhi while granting bail to the accused. Honorable judges, the desperation of the government to make example of the accused is thinly veiled. Next, when an individual is booked with conspiring, abetting, aiding, or inducing a terrorist act, the malified intent of the accused or the suspect solicit the essential characters of terrorism in conformity with the provisions of law, the contravention of which the accused has been charged with will have to be seen. Honorable judges, the defense latch on to the fact that the foundation of our nation stand on surer footing than to be likely to be shaken by a mere protest. The apex court has espied in Asif Iqbal Tana, and thus it is submitted that although the definitions in section 15, 20, 38, 17 and 40 of UAPA are wide and even somewhat vague. The definitions must partake the essential characters of terrorism and the related affairs and cannot be permitted to be applied in a casual manner. Honorable judges, as foisting extremely grave and serious penal provisions engrafted in the aforementioned sections of UAPA upon such innocent souls would undermine the intent and the purpose of the parliament in enacting a law that is meant to address the threats to the very existence of our nation. In a ploy to slap UAP on innocent souls, the prosecution solely relies on the custodial admissions beside the testimonies of the prosecution witnesses, which, as affirmed by our Indian criminal jurisprudence, holds no admissibility value in court of law. The council further gainsays the admissions and concomitantly recognizing the stark reality of the accused being usually enveloped in a state of fear, panic, and anxiety while being in a police custody, proclaims that the Indian Evidence Act, besides the legal jurisprudence, has excluded the admissibility of a confession that is made to a police officer. As has been further confirmed in various cases, some like Rajkumar Karwal versus Union of India and others, and Bhiru Singh versus State of Rajasthan, just to cite a few honorable judges. Moreover, a constitution bench of the Honorable High Court in Haricharan Kumari versus State of Bihar further clarified the legal position in this regard, and it is submitted that in dealing with a case that is against an accused person, the court cannot start with the confessions of the co-accused. And therein, the council reminded the court, and the court appreciated the fact that admissibility is one thing and the weightage to be attached to the evidence is another. Further, it is expedient to point out the corpus delicti rule, which certifies that a confession standing alone is not enough for a conviction, as unlike POTA, UAPA restored the normal status of confession of the accused as under Evidence Act. In addition to the above, there is no explanation as to why persons from public who were present during the time of the alleged incident have not been examined. In this regard, the Honorable Delhi High Court, in the case of Islam versus State, has observed that we take the testimonies of the prosecution witnesses, who in that particular case, apart from prosecution witness 5, were all the police officials. The court held that the prosecution cannot be said to have brought on record any substantially incriminating evidence, furthering their inability to prove the defense's guilt beyond a reasonable doubt. Honorable judges, the call records relating to their cellular phone numbers have not been proved as per the requirements of law, and their genuineness is in doubt. It is a humble submission before this honorable court that in the absence of a certificate issued under subsection 2 of section 65B of the Indian Evidence Act with particulars enumerated from in section A to E, the information contained in the electronic record cannot be adduced in evidence. And in any case, in the absence of examination of a competent witness who is acquainted with the functioning of the computers during the relevant time and the manner in which the printouts were taken of the call details, even the secondary evidence under such circumstances under section 63 will not be held to be admissible. Honorable judges, in closing, the happenings of the case are similarly as plain as day that it is the state's effort to slam false charges upon these innocent souls. And by the same token, the state deliberately interprets Sohail's abscondence necessarily as a conclusive evidence of his guilty mind. At this juncture, the council deems fit to bring your lordship's attention to the pronouncement of honorable court in the case of Sharad Bhirdhichand Sharda versus State of Maharashtra, and humbly submits that your lordship, graver the crime, greater should be the standard of proof. An accused may appear to be guilty only on the basis of suspicion, but that cannot be said to be amounted to be a verifiable legal proof. Where on the evidence there exist two possibilities: one that favors the prosecution, and the other that benefits an accused. The accused is undoubtedly entitled to the benefit of doubt. Honorable judges, with your permission, the council now seeks permission. With your permission, the council would now like to proceed with the prayer. Much obliged, honorable court. Whereof, in the light of the facts of the case, issues raised, arguments advanced, and the authorities cited, the counsel for the accused most humbly pray and implore before the Honorable Court of Law and its Special Judge NIA that it may be graciously pleased to adjudge and declare the accused to be freed of penal charges under sections like 120B, 489B, 489C, 121, 123, and 201, as well as of UAPA charges under Section 16, 17, 18, and 20. These charges levied on account of their alleged involvement as a member of the terrorist organization in invigorating the unidentified local militant groups to flourish. Secondly, the accused be deemed innocent and set at liberty in consonance with the state's inability to prove accused malified intent to execute a terror conspiracy aimed at destabilizing India's economic security beyond a reasonable doubt, and in all, pass any order as it may deem fit in the interest of equity, justice, and good conscience. For this act of kindness, the defense shall be duty bound forever.
Team 530, rebuttal.
Yes, sir. May I have your permission, Your Honor, to please proceed with the rebuttals? So your mic is mute.
I'm sorry. Yes, please go ahead. Yes.
Thank you, Your Honor. Your Honor, before starting, I'd say that although as commendable as the cases, meaning, definitions, rules stated by the defense, none of it actually refer to the present case, as they did not really speak about the facts of the present case. Onus was on the defense to prove that they were not liable under UAPA. Rather, they denied, saying that they were framed by police, contradicting the witness statements and confessions, which are which are directly admissible, because 25 of IEA lays on confessions and not witness statements. Your Honor, they also spoke about extended detention and human rights being violated. Your Honor, say that justifying the human's right being exploited at the principle that innocent until proven guilty does not apply when the life of whole nation is at stake, not to mention the damage it would have caused if it had been successful. Also, Shah Rukh Khan is not a witness, rather the source used by Delhi Police Special Cell to identify the house of Sahel. And as for the bail stance, there has been no initiative by the defense in the past. An agreement was there to go against the policies, as they said that there was no agreement. The agreement was always there when they understood what the organization was working on, and Samir and Monu worked under the initiative at the once. They just attending one meeting and started working for the association when they started searching for people to raise funds for the same and for the sensitization programs, according to them, which were declared unlawful by the government, not to forget. About the fear and panic they've spoken about in the police custody, nothing such has been contended by the witnesses in any of their witness statements. Forget about the confessions. And thus the defense is questioning themselves, and there has been no evidence on their part for the same. What honor? Rioting is against the public tranquility, whereas joining an insurrection against the government of India is also a forming part of war, according to the provisions laid down by UAPA and IPC. We live in a democratic country, but we cannot surpass our rights on the stake of human lives, as the boundary established by Article 19 of Indian Constitution itself justifies. Honor, also not to forget the pattern established and the circumstantial evidence found by the prosecution councils and NIA and police custody. They were all corroborated by the facts and circumstances appeared under Section 27 of IPC, and also the special mention of Naxals and Maoist community, of how they started and where they are now, directly relates to the present case, Your Honor. That's my Your Honor. If any questions, thank you.
Yes, the other side, please.
Much obliged, Honorable Court. My friend mentions rioting. It's not, it wasn't. It's contended that it's not rioting. It was a public. It was the right, or the accused were working in consonance with their right to protest against the government, because the right to protest is the basis of a democracy that Union of India is. So writing would be a great misconnotation of the same. Again, actus reus and mens rea has been mentioned by my learned friend. Actus reus, it's presented before the honorable court. Then neither the actus reus, neither the mens rea has been sufficiently proved. The counsel, my friend, learned friend, is relying on the call records. The call records do not show communication or any shred of evidence which shows that they were conversing with each other with relation to the criminal activities, as has been alleged by my learned friend. It just shows communication in the first. The circumstances, again, which have been mentioned, which have been relied upon by my learned friend, the circumstances in the present case show that there has been a fabrication of evidence and the charge sheet, which goes on to bring about the tampering which has been done by the national police authorities, and the secret information which the informant got, again go on to show that the reliability of the information thereon. The CFSL report, again, the my learned friend contended that there's a period of 6 months. But under Section 6, the investigation of counterfeit currency offences rules to 2013, it's mentioned that 15 days are the reliable time within which the CFSL's preliminary report has to be presented. But the same was done on 16th of April 2015, which is it's
Discrepancy.
It's a discrepancy, and a more time has been taken rather than has been mentioned by Rule 6. Also, the speeches which talks about it further goes on to show the mens rea of the political party which was in power, that the mere writing, the mere speeches which were proved, or they were termed as anti-national. But again, speeches cannot be made out to put somebody under the label of a terrorist. Those are just, again, the exercise of the right to protest, which goes on to establish the charge or the lack of culpability of the accused in the present case.
Is that all?
Yes, Honorable Court.
Vivek, you want to say something?
Not really.
No, Vivek?
That's right.
I think all of you have done a tremendous job.
Very well argued.
You're making it our task difficult to mark each individual, because each of you stand by on your own legs very well. But unfortunately, we have to perform this function. So pardon us, one will win, the other will lose. But we will do our best to sort of decide what is the best for a particular team. Can we have could we have Mr. Vivek and me separately on the screen for 2 minutes for a mutual discussion?
Just a minute, sir. I will try.
Is that possible? If you can,
Sir, I have to see actually. I have to look
eliminate
into
all.
this.
Otherwise, I can speak to him on the phone. Vivek, you can tell me your number. I'll call you. No, I can't hear you. You're on mute.
Yeah. It's 9911
Yes.
57
Yes.
19
Yes.
61.
I'll just give you a ring. We'll exchange our views and then we'll.
Yes. Okay. Although I have done my marking.
Yes, that's all right. Vivek, even I've done it.
Fine.
Even I've done it.
Yes.
Thank you, Your Lordships.
Thank you, Your Honor.
Thank you, honorable judges.
You guys have to wait right now.
So meanwhile, Court Master, can we know when the results will be declared?
They will be declared shortly. As soon as we get the scorecard from the judges, we are going to share them before tomorrow morning.
Before tomorrow morning. Thank you. Okay.
Vivek, I cannot get connected. I think your phone is either switched off or it is.
Perhaps, you know, I have just got a new internet connection, the new
I see.
Wi-Fi in my office today, with a better frequency and all that. So maybe it's a bit erratic.
Okay, that's fine. Then we can mark. You can mark and I can
Yes. Fine. So I have marked.
I will now. How do we send it? Just we send it on the.
I thought I will just take a picture and send it to Mr.
So you
Rupinder
can just
Parsi.
sign it and you can just WhatsApp it to us or mail it to us.
Yes, so I'm
whatever
taking
way
a
you
picture. I'm taking a picture and just sending it to you.
No
Okay.
issue, sir.
Should I send it to Ridhima?
You can send it to both of us, sir. Anyone.
I
yeah.
have Ridhima's number.
Yeah, sir.
Oh, okay. Thank you, everybody.
Thank you, sir.
Thank
Sir,
you.
although
Thank
this
you.
is not
Thank you,
allowed
Sudhanshu.
and
Okay,
this is
all the
a
best.
criminal moot court, but on my side, I would like the students to know the experience you have in the commercial law. So, can you just share a few words if you desire?
Well, I actually, you're right that I'm actually practicing on the civil side. And now Mr. Ashok Kashyap had requested me to fill in today on the criminal side. But criminal law is equally very, very interesting. In fact, more interesting than any other law. But yes, you have your own aptitude, your own taste. And I think each individual has their own sort of liking and disliking. I have done a lot of commercial litigation, which, with arbitration in company law, which is the NCLT. Earlier it was the Company Law Board, or before that, also the Company Court in the High Court, and later the NCLT, NCLAT, and so on. It's been, well, I would say it's a lot of hard work, and there is no substitute, because civil law also is requires a lot of reading, requires a lot of understanding, of course, the fundamentals. The first principles first have to be clear in your mind. And once your first principles are clear, I think you can tackle all sorts of matters. But I'm sure that you are all very enthusiastic in the way we've seen you perform today. Whatever field you choose eventually, I'm sure that you're all going to do extremely well. We wish you all the best.
Vivek, sir.
Thank you, Vilas.
Few words, sir.
So all of you have performed extremely well. And, these days I find youngsters, interns, juniors, they're very, very much better than what, we were when we entered the profession. And there are many more opportunities available to youngsters today. Law firms, corporates. So I would only say, first of all, enjoy your work. That's most important. Be passionate about your work and be patient and perseverant. It's a marathon. The profession is a marathon. It's not a 100-meter race. So, initial years, you will find your contemporaries in the corporate world, going past you and getting all those promotions and everything. Don't feel disheartened. You will catch up very soon. And the more years you spend at the bar, the better you get. It's a gray-haired profession. So just enjoy, and that's it. It's a journey. It's a beautiful journey, and all the best to all of you.
Thank you,
so
sir.
much.
It's been an
Thanks,
honor.
sir.
Thank you.
Thank you, sir, for those very enlightening words.
So you're mute. Oh, the mic is on mute.
Sir,
I
with
send
your
the results?
permission, both of your permission, may we conclude today's session?
One minute. Yes, one second. Should I send
Yes,
the
sir.
results on the email ID from which I
Yes, sir.
received
As
the
you
link?
wish, sir.
All right. So it'll be easier for me. Yeah, that's fine. Thank you.
Okay, so that's
Yes, please conclude. Please conclude. Yeah.
Yes, sir.
Okay, so
Namaskar.
that's it.
Namaskar.